Judgment in the matter of Paul and another against the Royal Wolverhampton NHS Trust, Polmear and another against the Royal Cornwall Hospitals NHS Trust, and Purchase against Ahmed.
Lord Legate will explain the court's judgment.
Appeals in these three cases have been heard together because they raise a common issue. In each case, a person died because of what is admitted or assumed to be negligence of a doctor in failing to diagnose and treat a life-threatening disease. For present purposes, it is assumed that if the doctor had exercised proper care, the death would have been prevented. In each case, one or more members of the person's close family witnessed the death, and as a result of this traumatic experience, developed a psychiatric illness. In the first case, Paul, two young daughters were present when their father collapsed and died in a public street. In the second case, Polmear, parents were present when their young daughter died at her school. In the third case, Purchase, a mother on returning home came upon her daughter who had died just a few minutes earlier. In all three cases, it is agreed that the experience was a shocking one which caused a recognized psychiatric illness. The issue is whether the family members can claim compensation for their illness from the doctor whose negligence resulted in the death of their relative, or the health authority which employed that doctor. By different routes, the cases reached the Court of Appeal, which considered them together. The Court of Appeal decided, with some reluctance, that in law the claims cannot succeed and must therefore be dismissed. The claimants have appealed to the Supreme Court. By a majority of 6-1, this court dismisses the appeals. The court holds that while doctors owe a duty of care to protect the health of their patients, they do not owe a duty of care to members of the patient's family to protect them against the risk of illness that might be caused by witnessing the death of their relative from a condition which the doctor has negligently failed to diagnose or treat. The reasons for this decision are given by myself, Lord Legate, and Lady Rose in a joint judgment. Lord Carlaway has written a concurring judgment explaining that the law is the same in Scotland as it is in England and Wales. Lord Burrows has written a dissenting judgment, explaining why he disagrees with the majority decision. In very brief summary, the majority judgment starts by noting that for centuries, the general rule under the common law has been that a person cannot claim compensation for the effect on them of the death or injury of another person, however severe this effect might be. An exception has developed which allows a person to claim compensation for injury, usually psychiatric illness, caused by witnessing an accident or the immediate aftermath of an accident, in which a close family member or other loved one is killed or injured as a result of someone's negligence. By an accident is meant an unexpected event in which injury is caused by violent external means. Many of the cases have involved road accidents. In one case, for example, a driver lost control of a car which careered off the road into the middle of a family picnic. The claimant was not physically injured herself, but she saw her husband hit and killed and her children injured before her eyes. She developed a psychiatric illness. The negligent driver was held liable to pay her compensation for this illness. Here, the claimants have argued that this exceptional category of case is not limited to accidents. They argue that it includes, or should be expanded by analogy to include, cases where, as a result of a doctor's negligence, a person dies or manifests injury from a disease which proper treatment would have prevented. There are some earlier cases which have raised this question. We examine them in detail in our judgment, but they do not provide any conclusive answer. We also consider the question as a matter of principle. We conclude that an analogy cannot reasonably be drawn between cases involving accidents and cases where the claimant is present when a close relative dies or manifests injury from a disease which ought to have been treated. Some of the relevant differences are these. Accidents are discrete events. It is usually clear and easy to determine whether someone was present at the scene and directly perceived an accident. Witnessing a violent accident involving a close family member can be expected to be a deeply distressing experience. By contrast, in the medical context, even where there is a death, there is often no discrete event comparable to an accident, as the symptoms of disease or injury may develop over days, months, or years. The symptoms witnessed by a family member may also be more or less severe. Unless the door is to be opened to claims based on direct perception of any symptoms, however mild, some test is needed to distinguish between claims which are and are not admissible. Counsel for one of the claimants argued that claims should be allowed only where the event witnessed is the first manifestation of a medical condition. Another test suggested is that the claimant can recover compensation only if the court judges that the event witnessed was sufficiently horrifying. For reasons discussed in the judgment, we do not regard any of the various tests proposed as acceptable. We also consider that to extend the scope of allowable claims to situations where the claimant witnesses the death or injury of a relative from disease would give rise to unacceptable and unfair differences in treatment between different categories of claimant. It would be impossible to explain to an ordinary reasonable person why, for example, compensation could be recovered by a daughter who sees her parent die from a heart attack, which should have been avoided, but is denied to, say, a mother who did not witness a road accident in which her child was fatally injured, but is present at the hospital when her child dies many days later from injuries sustained in the accident. It is also necessary to consider the role of a doctor and how far a doctor's duties reasonably extend. A doctor, of course, owes a duty to their patient to look after their patient's health. If the doctor is careless and the patient suffers injury as a result, the patient can in principle claim compensation from the doctor. But we do not accept that a doctor's responsibilities extend as far as protecting members of the patient's family from illness which they might suffer if their relative dies or manifests injury from disease at a time when they are present. In our view, in the current state of society, the point has not been reached where the experience of witnessing the death or injury of a close family member from disease is something from which a person can reasonably expect to be shielded by the medical profession. It is impossible not to feel the greatest sympathy for the claimants in these three cases, but the conclusion of the court is that the doctors responsible for treating their close relatives as patients did not owe a duty of care to them to protect them against illness. The doctors and health authorities are therefore not legally liable to compensate them for the psychiatric illnesses which they have developed as a result of witnessing the deaths of their relatives. The result is that the appeals are dismissed.
The court is now adjourned.